Duty to Protect statute is what we're going to talk about, and I wanted to give a little bit of background. Most of you are probably familiar with the term Tarasoff or the Tarasoff rule. Just wanted to give a little bit of detail for those of you who aren't familiar about what that case actually was and how it has morphed into what Ohio has in terms of protections. I can't see anybody for some reason, so I do hope everyone can hear me. Okay, Nicole's nodding yes, that's a good thing. All right, there we go. All right, so with Tarasoff, it began in 1969 in California. There was a grad student at UC of Berkeley. He had told his therapist that he planned to kill an unspecified woman, spurned love, essentially. He had made that threat a couple different occasions, and his therapist did call police, and he was taken into custody. She called for them to take him for hospitalization, but because he appeared calm and rational, the campus police released him. Shortly thereafter, the therapist supervisor ordered that he not be subject to further detention, and he had quit coming to therapy after that. I think it was about 2 months later, he killed Tatiana Tarasoff, and her parents sued, claiming that police had released the man without them being notified of the potential danger. And supposedly the victim could have been easily identified as Tatiana. So the case was decided quite a few years later in 1976. And what they said in California was a psychotherapist who determines or should be able to determine that a patient poses a serious danger to another must use reasonable care to protect the potential victim. When the California legislature wrote that into law in 1985, so this all was spread out over quite a period of time, they drafted it as a duty to warn requirement. I don't have the statute available in front of me, but it was pretty much saying that the duty is satisfied if the potential victim is warned. And since that time, many states have done some variation of that rule. It is important to note, however, that every state differs a bit in terms of how they enacted a duty to warn or a duty to protect statute. So you might hear from colleagues, especially at national conferences or what have you, or as part of national discussions, what Montana is doing or California is doing or Florida is doing. It's important to know this is a state-by-state requirement. So today we're going to focus on Ohio's version of Tarasoff. It's in law in the Ohio Revised Code, section 2305.51, and ours is titled Mental Health Professional or Organization Not Liable for Violent Behavior by Client or Patient. It was made effective in 1999, and it's considered to be a duty to protect statute. Ohio's a duty to protect state as opposed to duty to warn. And without going into all the detail about that, it's considered to be broader than a duty to warn, that you're not just warning, but you're taking action, and it requires more careful analysis in determining what action to take, which we'll get into here in a little bit. Frankly, to me, I know it's called a duty to warn or protect, but the way Ohio's is written, it's more of giving immunity from liability than stating it as an affirmative duty. As we get into it, you'll see it's not written as you're required to report or you're required to take action. It's written as if you do report or take action and something happens, you have immunity. We'll talk about it under some of the professional licensures and other rules. It becomes a mandatory duty, but the statute itself isn't quite written that way. So the duty to protect under Ohio's statute applies to mental health professionals and mental health organizations. And I have the definition there on the screen. So sole practitioner, anyone licensed or certified under Ohio law to provide mental health services, or an organization as a whole, of course, engaging one or more mental health professionals to provide those services. I've been asked in the past, repeatedly actually, about the statute's application to addiction professionals or those receiving addiction services. And I don't have all of the definitions and the full text of the statute in the presentation itself, but you will see that it is very specific to mental health services, mental health professional, organization, a mental health client. It talks in the definition of mental health client or patient as someone who is receiving a mental health service from a mental health professional. And then it goes on to give the common definition of what a mental health service would be. So for whatever reason, the legislature didn't in the beginning and has not since adapted this in any way to address addiction professionals. My guess would be because 42 CFR Part 2, the federal substance use disorder confidentiality law, is so stringent that most addiction professionals would not be able under federal law to report this information. And there has been no change to that law in decades, so probably no reason to add anything regarding addiction professionals since. And if there are questions when we get to the discussion portion that pertain to addiction professionals and similar situations and what they can do, we can talk about it at that time if there's an interest. But for purposes of this statute, it is specific to mental health services, clients, and professionals. The standard itself, what it says, and I mentioned I don't have the entire statute in this presentation, but it is pretty darn close. It's a short and sweet statute. I have it printed double-sided, and it's really less than 2.5 pages. So it is worth, as a mental health professional, just going and reading the statute when you have time. And frankly, the first page of it is definitions, and the latter half is a bit of additional protections for other professionals that I will mention as well. So in a nutshell, this is the standard, but again, it's pretty close to the actual statutory language. It says that liability under civil some type of civil action or disciplinary action under professional or regulatory requirements may result for serious physical harm or death that results from the failure to predict, warn of, and take precautions to provide protection from the violent behavior of a mental health client or patient when both of these apply, these bullet points. So the client or patient themselves or a knowledgeable person that we'll talk about here in a minute has communicated to that mental health professional or organization an explicit threat of inflicting imminent and serious physical harm or causing death to a clearly identifiable potential victim. And the professional or organization that has received that information has reason to believe that the client or the patient has the intent and ability to carry out that threat. So I underlined a few pieces there, and we'll talk about knowledgeable person here on the next slide, but essentially an explicit threat, imminent and serious harm or death, a clearly identifiable potential victim, and actual intent and ability to carry out the threat that's being communicated. If the mental health professional or organization does not take actions that we're going to talk about that predict, warn of, and take precautions from that threat, then there's liability or potential disciplinary action that may result if serious physical harm or death does actually incur. So in this slide, it says client or patient themselves or knowledgeable person. Knowledgeable person, it's a pretty broad definition. It's anyone who is either an immediate family member or otherwise personally knows the client, and they have reason to believe that those criteria apply. So if they are well enough known to the client or patient themselves that they have formed this reason to believe based on what was communicated to them, and they go ahead and communicate that information to a mental health professional or organization, that duty or requirement to take action in order to protect yourself from liability exists as well. So just keep in mind, it doesn't have to come directly from the client or patient themselves. And I go back and forth between client and patient because of just the different terminology used in more physical health as opposed to mental health setting, but the same thing there. There's nothing with all these definitions that changes there. So identifying the threat, as we talked about on this last slide, failure to predict the threat is essentially when you have received that information and you are predict, I don't think is the best word, identifying that what was communicated to you meets those underlined terms there. Your next step would be warning of or taking other precautions. And that's what's on this slide. These are also in the statute. The statute states that if you have made that determination and what was communicated to you, you believe in your professional judgment meets that bar, you're required to take one or more of the following actions. So you can choose to hospitalize the person, and how that's spelled out in the statute is you can convince them to voluntarily hospitalize. You can take the filing of an affidavit or judicial procedure route, or you can utilize the emergency or pink slip process to get the person hospitalized. You can also establish a specific treatment plan. The treatment plan must be reasonably calculated to eliminate the possibility the threat will be carried out, and at the same time, the professional is required to initiate arrangements for a second opinion risk assessment by having a management consultation about that treatment plan with another mental health professional, as I've stated here. If it's an organization, they have to discuss it with their clinical director. If it's a mental health professional, they have to have that consultation with another mental health professional that's licensed to engage in independent practice. And it's important in this option for action that the treatment plan and having that treatment plan consultation must go hand in hand. They must happen concurrently. And the third action that can be taken is notifying law enforcement, and that's to occur in the jurisdiction where either the potential victim resides, where a structure is threatened, or the client resides. Also, if it is feasible, communication has to be made to the potential victim or their parent or guardian, if applicable, in regards to the nature of the threat, that should say identity of the client and identity of each potential victim that was identified. So it's important to note that all of these, any of these that are taken, must happen in a timely manner. Essentially, as soon as you realize that a threat has been communicated that reaches that bar, you have to take in a timely manner as soon as possible one or more of these actions. And we'll talk a little bit about how you can make that determination. I'm sure when we have discussion after this presentation, we'll flesh that out even more. But I wanted to also give you really the remainder of what the statute says specifically in terms of this duty or the protection from liability. It says when you take one or more of those actions, the mental health professional or organization must consider each of the alternatives and document the reasons for choosing or rejecting each of them. So going back to these, essentially you have your three categories here. You need to document that you considered hospitalization, you considered the treatment plan approach, you considered notifying law enforcement, and then document what your thought process was in choosing one or more of these and rejecting the others. Statute also says when making that determination, you can give special consideration to the alternatives, which would least abridge the rights of the client or patient, rights they might have as a mental health client or a hospital patient or what have you. And you are not required to take an action that in the exercise of your professional judgment would endanger yourself, your organization, increase the danger to the potential victim or to the client or patient. So essentially when you are going through these, if you are rejecting any of them, one of your reasons for rejecting one of them might be because it would endanger someone or increase the danger to someone if you chose that action. And you can also state in rejecting a potential action that you chose one that would be least in violation of the rights generally afforded to your client or to your patient. So considerations and decisions around this, there are a lot, unfortunately. These are the terms in that first bullet point that I underlined in the statute. Essentially, it is up to the professional judgment of the mental health professional to determine whether there's the explicit threat. Is it imminent and serious? Is there a reason to believe they have the intent and ability to carry out? So explicit threat is a little more straightforward to determine. Keep in mind, imminent means very likely to happen soon. So if a client says, when Susan remarries, I'm going to kill that person. If Susan's not even engaged and not even dating anyone, that is not an imminent threat. Or maybe she is dating someone, but there is no marriage in sight. It's not an imminent threat because there is no marriage. Unfortunately, that's as granular as some of your determinations may need to go when you're making that initial decision of whether there's a threat that requires action. Intent and ability might be difficult to determine. Maybe you know that Susan lives down the street, but maybe Susan lives in California, and you might not know the details of that relationship or the ability, if the person says, they're going to shoot someone, do they have the ability to access and gain a weapon and to do that? Unfortunately, there are no definitions for any of those terms in the statute. And although these terms are sprinkled throughout other portions of Ohio statute, they're applicable in different contexts. Clearly identifiable potential victim is rather straightforward. Keep in mind when thinking back to the Tarasoff case, although the name had not been specifically stated by the client to his therapist, by all accounts, she was easily identifiable, that it was a well-known relationship around campus, and she could have easily found out, or campus police could have easily found out who she was. And then, of course, choice of action and the adequacy of the action are other very difficult considerations in this. And then, just some other potential complications. Is this a fleeting thought, or is there serious intent on the part of the person? Are they just venting in anger at the time? Risk of overreaction by the mental health professional, how to discharge your duty. So it is not an enviable position to be in. Some other overarching considerations are being able to predict the risk, wanting to protect your therapeutic relationship. Is this a fleeting thought? Am I overreacting? Is this, a legitimate threat? Your consideration of wanting to protect the confidentiality that you have with your client or patient, and then liability. So trying to essentially protect others from your clients while being concerned that they won't be honest with you, won't seek care, won't be straightforward in these situations. Couple other pieces I wanted to mention. When it comes to the confidentiality issues, of course, in general, you want to protect the confidentiality of your therapeutic relationships as much as possible. But it is important to note that HIPAA not only permits disclosures to avert a serious threat to health or safety, HIPAA also permits disclosures that are required by law. So that would be what's required under these duty to protect, immunity type statutes around the state. If the state statutes are requiring the action, then HIPAA is permitting the disclosure. I also pulled up some of the mental health professional licensure requirements. It's interesting, psychologists don't have anything specific to the duty to protect statute. It simply says that you may release confidential information in accordance with state law. The social worker, counselor, marriage and family therapist standards specifically reference 2305.51 and turns it into a mandatory reporting requirement. I mentioned early on, sorry, my printer just started printing something and I'm not sure why. Whereas I said early on that the statute is drafted more as a liability or immunity statute, the social worker and counselor requirements state that it is a mandatory reporting requirement for those professionals. So just wanted to give you something to reference in regards to your particular licensure. OMOS also has in their rules for their regional psychiatric hospitals, for their state hospitals, is it a rule or statute? It's actually a rule. It's in Ohio Administrative Code 5122.312, where they make this reporting mandatory, and they actually have more rules to assist in implementing this statute. And it could be helpful in your practice, your organization, to go and look at that Administrative Code 5122-3-12 for some helpful things to add to your policy or to your thought process. I thought I had a copy of it here, but I do not. But they actually talk about some additional considerations for deciding what action to take, for documentation. They even help with determining if some of those terms that are in the statute apply or not. So unfortunately, they haven't done that with the statute itself in kind of breaking it down, but that is one way. And they actually have a form in the appendix to the statute. No, that I do have. It's specific for the RPHs and their staff to use, but again, I think it is something very helpful for all of you to go look at. It's a form that when there is a threat communicated to a professional, a mental health professional, they actually have to walk through their thought process. They're required to document that an imminent threat of serious physical harm was communicated, by whom, when, relationship to the person, what was the nature of the threat. It is my judgment based on my knowledge of the patient whether they have the ability or intent to actually carry out the threat and why. And if you think they do, what action you are planning to take, and you actually have to look at the 3 different options I talked about and say which one you chose and why. So again, this form isn't required for use by anybody but those mental health professionals in the RPHs, but I think it is, considering Ohio law doesn't anywhere else have a required form or policy, it can be helpful in building yours. In terms of immunity offered under the statute, it does state, as I said early on, that you won't be liable in a civil action or subject to professional disciplinary or regulatory action for the violent behavior of your patient or client if you identify that risk and take action in a timely manner. You are also protected and not liable for disclosing confidential information for that purpose and taking any of the required actions. I also wanted to mention, this hangs out at the end of this statute. So when you go to look at the statute, the last section is a little bit different, but it is tangential to this issue. It states that physicians, physician assistants, advanced practice RNs, and hospitals aren't liable either if either they fail to discharge someone or allow someone to leave their facility if they believe there is a threat to the safety of the patient or others, or conversely, if they discharge one because in their professional judgment they did not believe the person was a threat to the safety of the patient or others. So that was added into the statute afterwards. It was probably just the best place to tack it on, but I wanted to make you aware that it was there. And then there are other areas of Ohio law that provide immunity to certain professionals, but say an exception to that immunity is failing to comply with this statute. So like under the hospitalization and commitment statute, it says you're not liable for harm for failure to disclose confidential information or failing to protect a person unless you didn't take action as provided for in the duty to protect statute. You know, bottom line with all this is dot the I's and cross the T's. Make sure you have policies and procedures in place. Give yourself some type of decision tree, something like the form for the RPHs to walk yourself through each piece of this. Utilize your peers when you can, even if you're not rising to the level of the treatment plan course of action, you know, consult with your peers, look at that RPH process, document each step, consideration, decision, and action. So bottom line is with everything in this field, document everything along the way. So that was my overview, and we